Good morning, stakeholders, and welcome to the Office of Procurement Regulations Complaints Sensitization session. I am Tamara Roy, Head Corporate Communications, and we're extremely pleased that you're able to participate in today's session. The team who will be presenting today are Sanchel Ferreira, Complaints Officer, Melissa Mano, and Nathifa Lowe, both legal officers at the OPR. Before we begin the formal aspects of today's proceedings, please allow me to go through some helpful tips for a successful session. Do note that your mics will be muted. Your questions during the session can be sent via the chat option on the Teams platform. These questions will be collated by our team and addressed in our question and answer segment at the end of the session. Please keep your contributions helpful and be considerate to our presenters and other participants. At the end of today's session, you will be invited to provide your feedback. So feel free to help us improve future sessions to better match your needs by letting us know what worked well and what did not. Please note that this session is being recorded and will be shared via email and uploaded to our website. So without further delay, we now welcome our first presenter, Sanchel, who will take us through an overview of the OPR. Sanchel.
Thank you. Good morning, everyone. Today, we are going to take you through the process of submitting a complaint to the OPR. We are going to give a brief overview of the OPR, and then the following topics will be addressed. What is a complaint under Part 4 of the Act? Who can make a complaint? What can I complain about? How to file a complaint? How complaints are handled? The possible outcomes if an investigation occurs? Distinguishing between whistleblowing reports from complaints under Part 4 of the Act. And finally, we will address frequently asked questions, followed by a short quiz to test your knowledge. The OPR, or the Office, is a body corporate established by the Public Procurement and Disposal of Public Property Act 2015 as amended. Our mission is to engender public confidence in the transformation of procurement, retention, and disposal of public property through an empowered, effective, and dedicated workforce, good governance and compliance, capacity development, and leveraging technology. The OPR stands on the principles of accountability, transparency, integrity, value for money, sustainable procurement, and sustainable development. Outlined in Section 13 and 14 of the Act, the OPR has numerous functions and powers. Today, we will look at those functions and powers that are directly relevant to the complaints process. The OPR's functions are to audit and review the procurement systems and disposal and retention of public property in public bodies, to review procurement practices and delivery systems on an annual basis, to identify best practices, and to investigate any alleged or suspected breach of the Act. The investigations can be prompted in two main ways. Firstly, by the OPR's own initiative. This may be a matter that comes to the attention of the OPR, perhaps from a newspaper article or online story of great public interest involving public procurement or disposal of public property. And secondly, upon receipt of a complaint. OPR's powers include the power to monitor procurement activities and disposal and retention of public property within public bodies, to conduct audit and periodic inspection of public bodies to ensure compliance with the Act, and to direct public bodies to ensure compliance with the Act. So now let's get into what exactly is considered a complaint under Part 4 of the Act. A complaint is a formal written statement of an allegation that bid rigging or any other form of collusion, an irregularity in procurement proceedings, or a breach of the Act has occurred. Next, who can make a complaint? In accordance with Section 41 of the Act, any member of the public may make a complaint regarding breaches of the Act. The OPR may also consider, inquire into, or investigate any alleged breaches of the Act where a complaint has not been made by a member of the public. I must reiterate at this point that it is very important for members of the public to bring forward complaints to the OPR of any alleged breach of the Act so that change in public procurement and disposal of public property can be truly effective. Let's get into what can be complained about. It is important to note that the OPR will only investigate complaints that are relevant to its mandate. Under Section 41(2) of the Act, there are 3 categories of complaints that can be brought to the attention of the OPR. These are bid rigging or other forms of collusion between all or any parties to procurement proceedings, an irregularity in procurement proceedings, or a breach of the Act. It is important to note that a breach of the Act also covers a breach of the provisions concerning retention and disposal of stores and equipment of a public body. In the following slides, we'll take a closer look at these areas. The first area is bid rigging. Bid rigging is defined as collusive, price fixing, and anti-competitive behavior, which is designed to unfairly influence the outcome of a competitive tender process. If we look closely at the photo in this slide, we can get a feel for how big bid rigging can occur. A, B, and C are bidders from separate entities who are all participating in this tender process. They have all prepared individual proposals, but it appears that they all have a silent agreement on understanding that B would be the winning proposal. In essence, they have agreed amongst themselves or colluded to directly or indirectly influence the outcome of the tender process in favor of B. In another tendering process, this same collusion may take place in favor of A or C. This type of behavior is an offense pursuant to Section 61 of the Act. You may also be interested to know that the definition of bid rigging was amended by Act number 27 of 2020. Next, we go on to irregularity in procurement proceedings. This may refer to a deviation from or non-compliance with the requirements outlined in the Act, the regulations, or the handbooks and guidelines issued by the OPR in accordance with the Act. These irregularities may also refer to loopholes that create favorable conditions for corruption within the procurement process. This includes the process of procurement from the planning stage, soliciting of tenders, awarding of contracts, and contract management. For example, Section 29(1)(e) of the Act requires that procuring entities ensure that suppliers and contractors have the necessary professional and technical qualifications and competence and financial resources to perform the procurement contract. Where procuring entities fail to do this, it may constitute an irregularity in procurement proceedings. Other examples include deviation from terms of request for proposals, failure to publish annual procurement plans, as well as failure to conform to pre-qualification regulations for procurement. Now we go on to breaches of the Act. A breach of the Act refers to the commission of an offense under the Act or failure to adhere to any of the obligations outlined in the Act. Examples of which are splitting of procurement. This is where a quantity of goods, works, or services are split into lots to avoid obligations under the Act. Breach of confidentiality. The procuring entity shall not disclose any discussions, negotiations that would prejudice the commercial interest of suppliers or contractors. Failure of a public body to refer all matters relating to the disposal of unserviceable, obsolete, or surplus stores or equipment to the disposal committee. It is important to note that a single complaint may have an overlap of categories depending on the facts outlined in the complaint. It is possible that one complaint can speak to all 3 of the elements that can prompt an investigation. You may be interested to know who a complaint can be made about. A complaint can be made about all public bodies. This includes the Office of the President, the Parliament, the Judiciary, a regional health authority, a municipal, corporation, the Tobago House of Assembly, a ministry, department, or division of a ministry. Also, complaints can be made against a statutory body, a state-controlled enterprise, any body or body corporate that uses public money, or in relation to any function that is exercised on behalf of the state, an accounting officer, parties to the public-private partnerships, a service commission, as well as a named procurement officer. It is important to remember that complaints against these persons and public bodies can only be made in relation to public procurement and disposal of public property. Now I will hand you over to Ms. Mano, who will take you through the next section of this presentation.
Thank you, Sanchel. Good morning to our listening audience. You might be wondering how you can file a complaint with the OPR. A complaint is filed with OPR by submitting a complaint form. This can be done online via mailing or walk-in submission to the OPR at Level 19 Tower D, International Waterfront Center, 1A Writing Road, Port of Spain. It is important to note when submitting your complaint that you include your name, mailing address, telephone contact details, email address, information about the subject of the complaint, particulars of the complaint, and supporting documents. A few important tips to note when submitting your complaint to the OPR are to please consult the guidance notes before completing the form. These notes can be found on the OPR's website at www.oprtt.org. Provide adequate supporting documents where possible. Use clear and concise language. Be specific. Use dates, times, locations, and names as far as possible. Provide the names of persons or witnesses who can provide evidence of the allegations made. Ensure that you provide up-to-date contact information so that you can be contacted by the OPR if necessary. Cooperate with the authorized officers of the OPR when called upon. How will your complaints be handled by the OPR? The complaint process involves several stages, which includes an intake of your complaint, an acknowledgement of your complaints, an initial assessment by the legal department, an investigation, if necessary, further assessment, and a final outcome. When you submit a complaint to the OPR, it is important that you submit a complete complaint form. The complaints officer will be there to assist you. He or she is your first point of contact and will provide any assistance you may need in lodging your complaint. She will ensure all formalities are met, but will not influence the substance of any information you may provide to the office. Once the OPR receives your complaint will be assigned the complaint number, and you will be issued an acknowledgement of receipt of your complaint, which will include your complaint number and the next steps. This acknowledgement will be communicated to you either at your email address, mailing address, or mode of service you provided to us. Your complaint is then sent to the legal department of the OPR. The legal department conducts an initial assessment of all complaints to determine whether there are sufficient grounds to warrant an investigation and whether your complaint falls within Section 41 of the Public Procurement and Disposal of Public Property Act. It is important to note that a complaint can be made in relation to bid rigging, any form of collusion between all or any of the interested parties to procurement proceedings, and irregularity in procurement proceedings, or any breaches of the Act. The OPR can also investigate these matters on its own initiative. Where there are insufficient grounds to warrant an investigation by the OPR, reasons will be provided to you. Where the legal department determines that a matter do fall within the remit of the OPR and there exists sufficient grounds to warrant an investigation, the matter will be sent to the Audit and Investigations Department for an investigation to be conducted. The Audit and Investigation Department will devise an investigation plan, gather all necessary evidence, conduct interviews, perform site visits, can enter and seize any vital information, documents, or materials, and in conclusion of an investigation, will prepare an investigation report. It's important to know that the OPR can, for the purpose of conducting an investigation, require any person to supply or produce to the office or to a person specified any book, record, documents, or information needed for an investigation. The OPR can also require a person to attend the office or any other place to give orally or in writing information on oath or affirmation. A person who is required to provide information to the OPR may be represented by counsel and may claim any privilege to which he or she is entitled. Where a person who is required to appear before the office or give information fails or refuses to appear or provide information without lawful justification, the office may make an application to the High Court to compel the person to do so. An authorized officer of the OPR can also, for the purpose of conducting an investigation, examine and inquire into the affairs of a public body or person, examine and make copies of any such books, documents, or records that is needed in an investigation, and can also enter the premises of a public body or person during reasonable hours for the purpose of conducting an investigation. However, an authorized officer of the OPR will not enter the premises of a public body or person unless the office first obtains on an ex parte application to a judge of the High Court an order authorizing him to enter the premises to conduct an investigation. The office will ensure that due process is adhered to at all times. It's important to note that the OPR does not have an unfettered power to enter into the premises of a public body or person for the purpose of conducting an investigation. The legal department must first file an application to a judge of the High Court stating sound and justifiable reasons, supported by affidavit evidence why such an order is required. It is only when the office is in receipt of a court order authorizing entry into the premises of a public body or person for the purpose of conducting an investigation will an authorized officer of the OPR enter the premises of a public body or person to conduct an investigation. On the conclusion of an investigation by the OPR, the Audit and Investigation Department prepares an investigation report and submits that report and an investigation file to the Legal Department for further assessment. The Legal Department reviews and determines whether the allegations made in the complaint are substantiated and prepares a report and recommendation for the Investigative Oversight Committee. It is important to note that the Investigative Oversight Committee is a committee that has been established by the board pursuant to Section 16 of the Public Procurement and Disposal of Public Property Act. The Investigative Oversight Committee reviews the report and recommendation of the Legal Department and makes the final decision on whether a matter should be referred to the Office of the Director of Public Prosecutions, together with any other recommendations. I'll now hand you over to Ms. Nathifa, who will take you through the other aspects of the presentation.
Thank you, Melissa, and good morning, everyone. So now that we have examined the complaints handling process, I'm going to take you through the possible outcomes after an investigation. The outcomes may vary on a case-by-case basis. However, the general main outcomes would be, number one, that there be no further action taken. Number two, that there be correspondence issued to the parties. Thirdly, that a notice of adverse report and an opportunity to be heard is given. And finally, that a report to the Director of Public Prosecutions is made. A determination on the outcome would be made after the Audit and Investigations Department has completed its investigation report. This report is then reviewed by the Legal Department and recommendations are made for the outcome. It is important to bear in mind that there may be more than one possible outcome at the end of an investigation depending on circumstances. Let's examine each of these outcomes in further detail. No further action. Where based on the findings of the investigative report, the Legal Department is of the view that there is insufficient evidence to substantiate the allegations made, they may recommend that the matter should be closed, meaning that there should be no further action taken. For example, the complaint may have been based on an allegation of bid rigging, However, the evidence obtained in the investigation may not establish the different elements of the offense that we discussed earlier in this webinar. In the process of review, the legal department will assess the reliability, credibility, and sufficiency of the evidence obtained, and that ensures that the quality of evidence meets an appropriate standard. So once the evidence does not meet that appropriate standard, the likely recommendation would be that there should be no further action taken. Furthermore, where the evidence obtained cannot be strengthened by further investigation, and this is after all reasonable lines of inquiry have been pursued, there will be no further action taken. Ultimately, where this decision is made by the office, the parties will be informed accordingly. Next, we'll deal with correspondence to the parties in accordance with Section 44 of the Act. This section states that after conducting an investigation under this Act, the office shall, without delay, in writing, inform the affected parties and the minister, the chief secretary, or the public official having responsibility for that body of the result of that investigation, and make such recommendations as it considers necessary in respect of the matter which was investigated. In fulfilling this duty, the OPR will consider the specific facts and circumstances of the complaint and provide recommendations that are targeted and relevant to the public body or person under investigation. These recommendations will be based on the Act, the regulations, the OPR's handbooks and guidelines, and best practices in public procurement and disposal and retention. It is an important aspect of the complaints process because this provides the OPR with the opportunity to give guidance to public bodies in the face of a complaint. Parties are therefore able to learn from their mistakes and minimize such occurrences of complaints in their future activities. Next, we're going to deal with the notice of adverse report and an opportunity to be heard under Section 48 of the Act. According to this section, the office shall not make a report which concludes that a public body or a person has failed without reasonable justification to fulfill a duty or obligation under this Act, unless reasonable notice has been given to the public body or person of the alleged failure, and the public body or person has been allowed a full opportunity to be heard, either in person or by an attorney at law. Essentially, this section is saying that where the findings of an investigation establish some level of wrongdoing or failure to comply with the Act on the part of the public body or person, it imposes a duty on the OPR to present those specific allegations and findings to that public body or person and to provide a response before the office makes a final determination into the matter. It gives any person or public body under investigation a reasonable opportunity to put forward any explanations, evidence, or arguments in their defense where they are presented with adverse findings. A failure on the part of the OPR to properly observe this duty can jeopardize and nullify any investigation conducted and may expose the office to civil liability. Some of you may recall that in the year 2004, the Integrity Commission commenced an investigation against a member of Parliament in relation to deciphering of materials from the Scarborough Hospital site under the Integrity in Public Life Act. The Integrity Commission was bound by the same duty in their statute, which is to give a notice of adverse finding, but failed to afford the Member of Parliament an opportunity to respond to the allegations against him before their report was concluded and sent to the office of the DPP for action. In 2009, a High Court judge found that the Integrity Commission acted in bad faith and was guilty of misfeasance in public office and they were ordered to compensate the member of parliament in damages for their failure to observe this statutory duty. This provision within the Act ensures that the OPR observes the rules of natural justice and procedural fairness. Ultimately, these procedures are meant to inspire trust and confidence in the OPR's complaints process. The final outcome that we're going to speak about is a report to the DPP under Section 45 of the Act. This section provides that where after the conduct of an investigation, the office is satisfied that there are reasonable grounds for suspecting that an offence has been committed, it shall make a report to the Director of Public Prosecutions, who may take such actions as he thinks appropriate. So if you look through the Public Procurement and Disposal of Public Property Act, you will see that there are provisions which create criminal offences with penalties attached to them. These are in the form of fines as well as sentences of imprisonment. The Office of the DPP is the body authorized by the Constitution of the Republic of Trinidad and Tobago to prosecute these criminal offences. The decision to invoke Section 45 of the Act is a serious step that affects the subject of the investigation and witnesses, and it must be undertaken with utmost care. It is for this reason that the OPR must be satisfied that on an objective assessment of the evidence, that there are reasonable grounds to suspect that the person in question has committed the offense. So you might be wondering, what does reasonable grounds mean? Well, this simply means that it is a finding based on reliable information that goes beyond a mere suspicion or allegation. The decision to make a report to the Director of Public Prosecutions must also consider the impact of any defense or information that the subject of investigation has put forward or on which they may wish to rely, as well as all material information available. It is important for you to know that where the reasonable grounds threshold has been met, the OPR must report the matter to the Director of Public Prosecutions in accordance with Section 45 of the Act. Once a report is made to the Office of the DPP's office has the final say in whether or not criminal proceedings or prosecution will be initiated. However, the OPR will maintain a line of communication with the DPP's office in relation to any matter that has been reported. I will now hand you back over to Ms. Tamara Roy.
So much, Nathifa. At this time, we will take a 5-minute break. We will place a timer on the screen and we will resume with more presentations. So see you back in 5. All right, welcome back, ladies and gentlemen. We will continue on with Nathifa Lowe presenting on the protection for complainants. Nathifa.
Thank you, Ms. Roy, and welcome back, everyone. So now that we've gone through the complaints process and spoken to you about the outcomes after an investigation, we understand that the filing of a complaint in relation to breaches of the Act can be intimidating, so we thought it important to highlight the ways in which the Act offers some protection for complainants. So firstly, we have Section 47 of the Act. In your place of employment, you may obtain some information about breaches of the Act relevant to procurement or disposal, and you may wish to file a complaint. However, based on the nature of the terms of your employment, you may be bound by a duty of confidentiality to your employer, and that might worry you because you would think that you would be in breach of your duty if you file a complaint with the OPR. Well, according to Section 47 of the Act, notwithstanding any other written law, no person shall be regarded as having breached any duty to which he may be subject by reason of his communication in good faith to the office of any information or opinion on a matter which is relevant to any function of the office under this Act, whether or not in response to a request made by the office. The effect of Section 47 is that you are not deemed to be in breach of any duty of confidentiality or otherwise in providing information to the office, provided that you act in good faith. This means that you can't make a complaint to the OPR maliciously and expect to be afforded this type of protection. This protection in Section 47 applies whether or not the OPR requests this information from you or whether you volunteer the information to the office by way of a complaint. Next, we're going to speak about victimization. This is another main reason why, especially employees, may be afraid to file a complaint because they are afraid of being victimized. In the context of the workplace, victimization can be dismissal, suspension, demotion, harassment, discipline, denial of a benefit, or otherwise negatively affecting a person. The Act prohibits this kind of retaliation or manipulation of procedures in relation to any person who, acting in good faith and on the basis of a reasonable belief, has notified the OPR, the Director of Public Prosecutions, the Integrity Commission, or the Trinidad and Tobago Police Service that his employer or any other person has breached or is about to breach the Act. This also applies where a person has done something to avoid having another person breach the Act, or also stated their intention to do so, where a person has refused to breach the Act, and also because his or her employer or any other person believes that he will do any of the things described above. A person found guilty of victimization is liable on conviction to a fine of $500,000 and imprisonment for 1 year. It is important for you to remember that if you feel that you are being victimized, you can make a report to the Office of Procurement Regulation, which will be investigated in accordance with the procedure that we have outlined today. So now that we've taken you through the complaints process, we will spend some time to distinguish the complaints process under Part 4 of the Act from the OPR's whistleblowing solution. The OPR's whistleblowing solution is managed by an external independent third party and is based on the OPR's whistleblowing policy, which is influenced by the status of the Office of Procurement Regulation as a designated authority in the Whistleblower Protection Bill 2018. That version of the bill was not passed, but was since relayed in Parliament in the year 2022. However, this piece of legislation is not yet enforced as the parliamentary process is still ongoing. There are notable differences between the OPR's whistleblowing solution and the Part 4 complaints process, which we'll examine a bit closer in the next slide. So first, we're going to compare who can submit a report under Part 4 or the whistleblowing solution. For Part 4 complaints, any members of the public can make a complaint under Part 4, as you've heard Ms. Ferreira explain earlier in this webinar. These can include contractors, suppliers, and public servants. For whistleblowing reports, similarly, members of the public can make reports under the whistleblowing solution, and these include contractors, suppliers, public servants, as well as employees of the OPR or a member of the board of the OPR. What can be the subject of the report? We've discussed earlier today that under Part 4 complaints, the subject of a complaint can be an irregularity in procurement proceedings, bid rigging or other forms of collusion, and any alleged breach of the Act. However, under the whistleblowing solution, reports can be made in relation to improper conduct. This is conduct that can result in a miscarriage of justice, is likely to threaten the health and safety of persons, or shows discrimination. These reports can also include irregularities in procurement proceedings. So you can see from this definition that the nature of reports under the whistleblowing solution is much wider than Part 4 complaints. How can a report be made? For Part 4 complaints, completing the complaint form is mandatory to submit the complaint, and you can do so via any of the available channels, which is walk-in, mail-in, or online submission. Under the whistleblowing solution, however, you can make the report online via the Integrity Counts platform and via the toll-free hotline. Do I have to reveal my identity? For Part 4 complaints, yes, you do have to reveal your identity, as valid contact information must be provided on the complaint form. However, for the whistleblowing solution, it is not mandatory for you to reveal your identity, as you are allowed to submit anonymous reports, and revealing your identity is optional. Am I protected? We just spoke about the protections afforded to complainants under Section 40 and 47 of the Act, which deals with victimization and also securing a person against being accused of having breached a duty. For the whistleblowing solution, however, the protections that are usually afforded in whistleblowing legislation are not yet available because of the status of the legislation. As I've mentioned earlier, it is not yet enforced. However, under the OPR's whistleblowing solution, protection is similarly afforded in accordance with Section 40 and 47 of the Act. How are my reports handled? For Part 4 complaints, an investigation report is prepared after the investigation and reviewed at multiple levels within the OPR, as was described earlier. This is done before a final determination is made in relation to the complaint. For the whistleblowing solution, the report will be handled by a whistleblowing reporting officer and the whistleblowing reporting committee before final determination. And finally, what are the potential outcomes? Under Part 4 complaints, a report to the DPP will be made where there are reasonable grounds for suspecting an offense has been committed. There will also be recommendations made to the parties in accordance with Section 44 of the Act. Under the OPR's whistleblowing solution, wrongdoing will be reported to the appropriate body so that corrective action can be taken. This includes, where appropriate, reporting to a law enforcement authority. As a final note on the OPR's whistleblowing solution, the OPR is mindful of the fact that reports about breaches of the Act may be received through the OPR's whistleblowing solution. This is because the definition of improper conduct also covers irregularity in procurement proceedings and breaches of the Act. Therefore, once these reports of breaches satisfy the requirements of Section 41, these will be investigated in accordance with the procedures for Part 4 complaints, as was outlined in this webinar. I will now hand you back to Ms. Mano, who will explore frequently asked questions concerning complaints.
Thank you, Nathifa. Some important frequently asked questions you may wish to know are: how does the office deal with misleading complaint? There's an offense to knowingly or mischievously make a false report to the office or mislead the office by giving false information. or make false statements or accusations. A person who is found to have provided a misleading report to the office is liable on conviction to a fine of $500,000 and imprisonment for 1 year. Can I make a complaint on behalf of someone? The answer is yes. A complaint may be made on behalf of another person. If you're making a complaint on behalf of someone else, you must ensure to include all pertinent information in the complaint form. Can I withdraw my complaint after it has been filed? Yes, you can. Where you wish to withdraw your complaint, you will be encouraged to communicate this decision to the OPR in writing. The OPR will consider whether the matter is one to be investigated on its own initiative. How long does the office take to investigate a complaint? The Act does not impose a deadline for investigating complaints. However, the office undertakes to ensure that all complaints are dealt with and investigated in a timely manner and will avoid unreasonable delay in all circumstances. What is the consequence of withholding or concealing information from the OPR? Well, it is an offense to withhold, conceal, or destroy or refuse to produce any books, documents, or records that are required for the purpose of an investigation under the Act. A person who engages in such activity is in breach of the Act, and such breach may be investigated by the office. If convicted, the penalty is a fine of $5 million and 10 years imprisonment. Will my complaint be kept confidential by the OPR? Yes, all complaints made to the OPR will be kept confidential and will only be disclosed in the following situations: where it is necessary to progress the investigation of the complaint, disclosure is required by court order or by a law enforcement agency or the Office of the Director of Public Prosecutions.